Okay, we need to learn about the UCC for claiming our collateral. Now, I know that there's some people that don't even believe in secured party or secured party creditors. But when you go to the UCC, that's Universal Commercial Code, you're going to see things that say security agreement and secured party. So people like you, Enrico, you know who you are, always saying, such a naysayer, saying there's no such thing as a secured party. Well, let's go there and find out what the deal is, okay? Because when all crimes are commercial and you have to operate as a business and you have to do UCCs or liens or what have you as a business, there's such a thing. So let me look to see if I can share the screen. So I'm looking in New York. Okay. Open this up. Let me see. I'm hoping that everyone can see this, because sometimes I wish I knew it all, but I don't know how to do everything. There are some things I know, like Earth is not a globe. Earth is landmass. I know about that. But let's see. I don't know anything about this. So this is the Department of State when I went on New York, because that's where a lot of people have their secured party securities, UCCs, and all that good stuff. So let's just read what this says. This is filing under Article 9 of the Uniform Commercial Code. The Department of State can neither provide legal advice, well, listen to them, nor any hard and fast rules that will govern all filing situations. However, some general guidelines regarding filings include the following. Under, oh, Eric, by the way, you might want to read revised Article 9. The responsibility for determining the proper place of filing for both original financing statements and any associated secondary filings rest with the filer. So if I or you were going to be going on a website with your state or the state of New York to do this, everything's going to rest upon us. So that means we're going to need to know the ingredients. Like if we're going to ever take on responsibility for anything we might get, we want to look at the material safety data sheet, know the ingredients, what's going to go inside of us. Same thing here. We want to know the ingredients. What is this all about? What's in it? Is it good for me or not good for me? So we're going to read this here. Governing state law. In many cases, but not all cases, the law of the jurisdiction in which the debtor is located will govern perfection and priority issues. The filer should consult Part 3 of Article 9. So we're going to have to do that to determine whether the laws of New York State or the laws of some other state govern perfection and priority issues for the filer's transaction. So I'm in California, but my things are filed in New York. So let's see what's going on here. The responsibility for determining whether the laws of the state of New York, or New York State, excuse me, or the laws of some other state, like California or other places, govern perfection and priority of security interests rests with the filer. So that would be us if we're going to be filing. The following discussion applies in situations in which the laws of New York State govern perfection and priority. Original financing statement. So, you guys have all heard of UCC 1. Well, this would be the original financing statement right here. Section 9501 governs place of filing. Subsection A1 provides that the office in which to file a financing statement to perfect the security interest or agricultural lien is the office designated for the filing or recording of a record of a mortgage on the related real property. This is the office of the county clerk or New York City Register. If 1, the collateral is as extracted collateral or timber to be cut, or 2, the financing statement is filed as a fixture filing and the collateral is goods that are or are to become fixtures, or 3, the collateral is a cooperative interest. Subsection A2 provides that the office in which to file a financing statement to perfect a security interest is the office of the Secretary of State in all other cases. Pursuant to subsection B, a fixture filing for a transmitting utility would also be filed with the Secretary of State. Did you pick that out? It says B, a fixture filing for a transmitting utility would also be filed with the Secretary of State. Have you guys heard of transmitting utility? The name being the transmitting utility. Have you guys heard of that before? Yeah, we aren't the transmitting utility, but sometimes I use that all caps name of yours as a transmitting utility. So that right there says it also would be filed with the Secretary of State. So here's amendment. Okay, you guys, this is a different piece of paper altogether. This is the UCC 3 because you're making an amendment or an assignment or a continuation or a termination, meaning, you know, it's done with, you don't want that anymore. This is a separate one, UCC 3. The first one over there, UCC 1, was the original one, but 3 is the addendum, okay, or amendment. It is the responsibility of the filer to determine which of the following may best meet the needs of his or her individual situation. So like in my case, I want to claim the car that I just purchased from a total reprobate, Will Tipton. Being that the reprobate never had it in his name, he's causing me grief. So I need to put a claim on the car that I purchased from the reprobate. Okay, meaning he's a really bad, evil person. And I need to put a claim on the car. So nobody will take it away from me because I paid for it with lawful money. Okay, so in the case of an original financing statement that was filed in the office of a county clerk or the office of the New York City Register that only provided for collateral that would properly be filed in that office under Article 9. That office is the proper place for filing an amendment, assignment, continuation, or termination statement. In the case of an original financing statement, that would be that UCC 1, filed with the Department of State that only provided for collateral, that would properly be filed with the Department of State under Article 9. So I'd have to take a look at the one that I have to know if mine was filed with the Department of State. That means I'd have to actually, get all my paperwork out. This is what sucks when you pay somebody to do something for you. And of course, they don't tell you what they did. You have to make sure you read your paperwork to see what they did. So that's really important. This is why this is good for us to read this, and then we can be responsible to know what was done where. So like, because this paragraph right here is talking about, there's one case right here, look, you could be filing it in the office of a county clerk or the office of New York City Register. Then you would need to, of course, do your addendum in the same place. Or number two, in the case of an original financing statement, which is that UCC one, it was filed with the Department of State that only provided for collateral. That would properly be filed with the Department of State. Do you understand what this is saying? So either you went to the county clerk, you'd have to do your addendum with the county clerk. If you went to the state, you'd have to do your addendum or amendment with the state. So you got to read your UCC 1 to see if it was the state or if it was the county clerk. You just have to read your stuff to see and make a decision. So the proper place for filing an amendment, assignment, continuation, or termination statement is the Department of State for the Department of State. Okay. Or if you were to do the county clerk, then it would be the county clerk. Or the office of the New York City Register, then it would have to be that place. So in the case of an original financing statement that was properly filed in both the office. Did you see that? Number 3, how it said properly filed in both the office of a county clerk or the office of the New York City Register and with the Department of State that provided for collateral that would be filed with both offices under Article 9. So this could be a problem when it's not properly done. If you're not doing with both, then it's not properly done. So we have to look at the paperwork to see if it had been done with both. If it only had been done with the state over there, and then wherever you reside or live or travel to or sojourn to, if it's in your county, that probably needs to be filed there too. That's what I'm thinking. So let me see. And with the Department of State, they're provided for collateral that would be filed with both offices under Article 9. For example, a fixture filing with other general collateral. The secured party, hey, did you see that? Did you see that word right there, Eric? The secured party. This is coming from New York State. I'm pretty sure every state has UCC filings in their state. So if you ever didn't think that there was something called a secured party, you're wrong. Boom. There it is in their writings, the secured party. So the secured party, that's the one that has the security agreement filed, by the way. And they have a UCC 1, by the way. Should file an amendment, assignment, continuation, or termination statement with both offices. Okay. That's what that says. Excuse me. So here we go. Exact name of debtor required for UCC filings. And you know that the debtor is going to be the all caps name, right? Article 9 of the Uniform Commercial Code requires a financing statement to include the name of the straw man, the debtor. It is important to set forth the exact legal name of the debtor in any filings that are made. Financing statements are indexed under the name of the debtor, and persons wishing to find filed financing statements search for them under the debtor's name. Subsections B and C of Section 9(506) of Article 9 provide the following. B. Financing statement seriously misleading, except as otherwise provided in subsection C. A financing statement that fails sufficiently to provide the name of the debtor in accordance with Section 9-503 is seriously misleading. I'm looking on the one that was done for me by a certain corporation that had an owl. And I'm looking to see all this information to see if it was done properly. C. Financing statement not seriously misleading. If a search of the records of the filing office under the debtor's correct name, using the filing office's standard search logic, if any, would disclose a financing statement that fails sufficiently to provide the name of the debtor in accordance with Section 9-503A. The name provided does not make the financing statement seriously misleading. The Department of State's standard search logic under Article 9 will return the exact name of the debtor requested. Failure to set forth the exact name of the debtor in a financing statement may result in the names not being returned by a search request under the exact name. A financing statement may not be effective in those cases. So you want to make sure that if you put the name down on the UCC 1, you got to put it down the same way when you're going to do an amendment for the UCC 3. It's got to be the exact same. Section 9-503 of Article 9 regarding debtor name provides the following. Section 9-503, name of debtor and secured party. Name of debtor and secured party. A. Sufficiency of debtor's name. A financing statement sufficiently provides the name of the debtor. 1. If the debtor is a registered organization, only if the financing statement provides the name of the debtor indicated on the public record of the debtor's jurisdiction of organization, which shows the debtor to have been organized. That sounds like an organization, a registered organization. 2, if the debtor is a decedent's estate, dead person's estate, only if the financing statement provides the name of the decedent and indicates that the debtor is an estate. 3, if the debtor is a trust or a trustee acting with respect to property held in trust, only if the financing statement, A, provides the name specified for the trust in its organic documents of, if no name is specified, provides the name of the settler. Ooh, look at that. Notice how it's with an O, the settler. And additional information sufficient to distinguish the debtor from other trusts having one or more of the same settlers. And B, indicates in the debtor's name or otherwise that the debtor is a trust or is a trustee acting with respect to property held in trust. And 4, in other cases, A, if the debtor has a name, only if it provides the individual or organizational name of the debtor. And B, so they're going over all the different qualifications here for putting down the name, because we're under the name of debtor and secured party. So B, if the debtor, and you know that you are not a debtor, right? You are actually a creditor. Did you know that you're a creditor? You are not a debtor. You're a creditor. Debtor is the all caps name, or the dead name, or the stallman. If the debtor, the organization or whatever, does not have a name, only if it provides the names of the partners, partnership, huh? Members, associates, or other persons comprising the debtor. Little b, additional debtor related information. A financing statement that provides the name of the debtor in accordance with subsection A is not rendered ineffective by the absence of 1, a trade name or other name of the debtor, or 2, unless required under subsection A, 4, capital B, name of partners, members, associates, or other persons comprising the debtor. And you can listen to this video a few times if you don't understand it all. Little c, debtor's trade name insufficient. A financing statement that provides only the debtor's trade name does not sufficiently provide the name of the debtor. Little d, representative capacity. Oh. Failure to indicate the representative capacity of a secured party. Hey, there's that term again. Or representative of a secured party does not affect the sufficiency of a financing statement. So the Department of State assumes no responsibility for determining whether the debtor's name complies with the requirements of Section 9503 in the Uniform Commercial Code, or for the correct spelling of a name. So you got to be, you got to be the one to make sure that you spell your own name right, or spell the name of the debtor right, that they're trying to sew their shadow onto you. Okay, so let me see. The department will enter the name of the debtor exactly as it is set forth in the debtor's name section of the financing statement. Example, in item 1, let's look up item 1. The initial financing statement file number. Okay, so like if you had a UCC 1 filed, then you were going to do a UCC 3 because you're going to add something in there like the car. Number 1 says to put the file number of the UCC 1. So that's what you'd be doing is put, obviously you have to have the UCC 1 first in order to put that number in line 1 for the UCC 3, which is the amendment. So here's what they're saying right here. In item 1 of the UCC financing statement form, including what may appear to be titles, designations, extraneous information, and typographical errors, it is the filer's responsibility to provide the correct name of the debtor in the debtor's name section in the financing statement. I'm looking on here to see. I see where it says organizational name, but that's on 6. So, for example, if the debtor is a corporation formed under the laws of New York, and if the name of the debtor as it appears on the records of the New York State Department of State is ABC Manufacturing Corp., or in this case, in mine, it would be the all caps name trust. The name should be set forth in the debtor's name section of a financing statement. Example, in item 1A of the UCC financing statement form, UCC 1, exactly as that name. So you have to look at your UCC 1, and I'm pointing over there because it's back there. I don't feel like getting up to go get it. I might have to though. You got to make sure that that name is the exact name when you get ready to add something on. That's all they're saying. So some common errors when setting forth the organization's name in the debtor's name section of a financing statement include the addition of trade names, the addition of descriptive or extraneous information, abbreviating words, or failing to provide the complete name. Some examples of common errors include providing the following in the debtor's name section of the financing statement. So these are examples here. You can see how it's all ABC Manufacturing Corp., right? But see how they added extra things? A New York corporation, or doing business as Albany Tools. So see how they have different, XYZ Enterprises, also known as John Smith, blah, blah, blah. Note, in the case of a debtor that is an organization, the financing statement must indicate the type of organization. Like, is it a corporation? Is it a partnership? Is it an LLC? Mine, 6A organization, says it's a trust. So, and the jurisdiction of organization. However, as indicated in example B above, B, up here, a New York corporation, this information should be given in some other place in the financing statement in lines 1E. Let's see what 1E is, or 1F. So tiny. 1E or 1F. I see 1A, 1B. I see termination, assignment, continuation, party information change. If you wish to include a trade name of a debtor in a financing statement, it is suggested that the trade name be set forth as a separate debtor. Example, provide the debtor's legal name. Provide the debtor's legal name, you know, the legalese straw man all caps name, as the name of the debtor in line 1A of the UCC 1 form. Oh, and provide the debtor's trade name as an additional debtor. Oh, in line 2A of the UCC 1 form. That's UCC 1. Provide all required information, like the debtor's mailing address. You know, that little post office box or a business address. Where are we here? All right. Designation of the debtor as an organization, designation of the type of organization, and designation of the jurisdiction of organization for both the debtor's legal name and the debtor's trade name. So both the debtor's legal name and the debtor's trade name. Oh, I got you. Up here, see that? So they got their legal name right here, John J. Smith, doing business as ABC Manufacturing Corp. Interesting. Okay, so in the case of an individual, the name set forth should be the correct name and only the correct name. You should not include titles or other similar designation. For example, in the name of the debtor is John J. Smith. The name should be set forth in the debtor's name section of a financing statement. Example, in item 1B of the financing statement form, UCC 1, exactly as John J. Smith and only John J. Smith. Some common errors when setting forth the individual's name in the debtor's name section of the financing statement include the addition of titles like Mr., trade names, Esquire, and also known as designations, and the addition of descriptive or extraneous information. Junior. Some examples of common errors include providing the following in the debtor's name section. Oh, here, these are the examples down here. Yeah, Mr. Like this is what they did, look. Mr. John G. Smith, or just John Smith, or they put John J. Smith Esquire, or MD, or CPA, John G. Smith, debtor in possession, doing business as ABC Manufacturing Corp, or also known as John J. Smith. Again, if you wish to include an individual's trade name or an also known as designation, it is suggested that the trade name or also known as designation be set forth as a separate debtor. So they're saying don't put it on the same line, do separate. Example, provide the debtor's correct name as the name of the debtor in line 1B of the UCC 1 form, and provide the debtor's other name as an additional debtor name in line 2 of the UCC 1 form. So that's the original form, UCC 1, okay? You must also include a complete mailing address for both names in both items. Note, in the case of a debtor that is an individual, the last name of the debtor must be identified. Can't just say John got to put John Smith. It is recommended that all filings be accomplished using the UCC forms. So if you're going to do that, you got to use those forms. Uniform Commercial Code filing requirements. Here's the requirements. Legislation revising Article 9 of the Uniform Commercial Code was signed into law as Chapter 84 of the laws of 2001 and became effective July 1st, 2001. Filers should be aware that the Article 9 requires financing statements, right here, and other UCC records to include more information regarding the debtor than was previously required. For example, it is incumbent on the filer to ensure that the correct legal name of the debtor and the mailing address of the debtor are provided in the filing. The filing must indicate whether the debtor is an individual or an organization. If the debtor is an individual, the filing must identify the debtor's last name. And if the debtor is an organization, the filing must provide both the debtor's type of organization and jurisdiction of organization. It should be stressed that under Article 9, a filing office may refuse to accept a record for filing only for certain specific reasons. The fact that a record is accepted for filing does not necessarily mean that the filing is effective for the purpose intended by the filer. The filer is solely responsible for determining the proper office in which to file and for determining that the record to be filed contains the information necessary to make the record effective to accomplish the filer's purpose. You may wish to seek guidance from your own attorney regarding Article 9 and its requirements. So from this reading, you found out that there's a UCC 1, and then there's also an addendum, or what they call it, amendment, a UCC 3. You got to have the 1 on there first, and you got to make sure you put the proper name, or at least the correct name. So in my case, it looks like this is a UCC 3 that I'm looking at. So 1A has the file number that leads back or ties back to the UCC 1. This piece of paper is pretty empty looking. It doesn't have a whole lot filled out. Number 6 is the organization's name. It's the all caps name trust, and it has the copyright and trademark. And then when it gets down to 8, it just shows the collateral change, like adding collateral. So the following property is accepted for value, exempt from levy, and herewith registered in the commercial chamber, and is private property conveyance of the secured party as authorized representative of the debtor, all caps, papers of instruments, any and all documents of apostille by the Secretary of State of New York is now public record. And is owned by secured party. Secured party must be satisfied in full upon dishonor via settlement agreement via certified check and or certified documents of claim. And then we put continued on the number of the CAD. Is that, what is a CAD? I don't know. CAD. I don't know what that means. Conditional acceptance document? Don't know. Anyways, so then the bottom 9, we just have the 9B, individual surname. You have it in the proper spelling, not all caps. And then the first personal name, you put your first name hyphen, middle name with the colon, full colon. And then at the very bottom, you just secured party's signature. Yeah, put your name in the proper spelling with the hyphen and the full colon in there with the date. And then you do your collateral attachment. Whew, there's a lot of stuff on here. I will read it. This is the entry of collateral by trustee/secured party on behalf of the trustee/estate, colon, the all caps name trust, copyright trademark, in the commercial chamber under necessity to secure the rights, titles, interest, and value therefrom in and of the root of title from inception, as well as all property held in trust, including but not limited to DNA, cDNA, cell lines, retina scans, fingerprints, and all debentures, indentures, accounts, and all the pledges represented by same, included but not limited to the pignus, hypotheca, hereditaments, res, the energy, and all products derived therefrom, nunc pro tunc, contracts, agreements, and signatures, and or endorsements, facsimiles printed, typed, or photocopied, of owner's name predicated on the straw man, ens legis/trust/estate, described as the debtor, and all property is accepted for value and is exempt from levy. Lien places on debtor entities is for all outstanding property still owed, but not yet returned to trust from entities such as municipalities, governments, and the like, not on trust entity itself. Trustee is not surety to any account by explicit reservation indemnification. The following property is hereby registered and liened in the same. Oh. All certificates of birth document, put the number. Then you got the social security number, UCC contract trust account, prepaid account number, put that one. Then you got your exemption identification number. That would be the EIN. And it looks like it's the same as the social security number with no dashes, by the way. Is herein liened and claimed at a sum certain 100 million. Also registered security agreement number, and then you put that number down because you got to have a security agreement, I think, in order to have this UCC one. Then you get the hold harmless and indemnity agreement. You put that number down. Then you get the copyright under item number. You put that one down. Adjustment of this filing is in accord with both public policy and the National Uniform Commercial Code. Trustee, secured party, and then you put your name in the proper spelling with the hyphen and the full colon, is living flesh and blood sojourning upon the soil of the land known as California, or what state ever you're at, and not within fictional boundaries. Ooh, that sounds good. Territories, nor jurisdiction of any fictional entity, including fictional federal geometric planes. That's funny. Trespass by any agents, foreign or domestic, by such in any scheme or artificial to defraud. Full reverence and by all agents and corporations is unambiguously demanded and required. Culpa est immiscere se rel ad se non pertinenti. All property currently held or outstanding belongs to the trust administered by trustee secured party. Title 46 USC 31343 and Article 1 and 5 of the International Convention on Maritime Liens and Mortgages, 1933, held at the Palace des Nations, Geneva, from April 19th to May 5th, 1992, United Nations, UN. This maritime lien is under safe harbor and sinking funds provisions through the prescription of law of necessity and the doctrines of unconscionably and la mort cecit le vif, in accordance with applicable law, cardinal orders, ordinal orders, and commercial standards. Totally small. Look at that. It's so small. And look at the whole page. It's like, I don't really like the way that looks. I would have liked it to be bigger. I don't know why they made it so small when they did this for me. Sheesh. That's terrible. Oh, maybe they do it like that on purpose, so they really have to look. I don't know. I don't know why it's so tiny like that. But anyways, that's the collateral attachment right there for the UCC 3. Okay, so hopefully that helps to read a little bit of that. All right. And if you get stuck, listen to it again or go on your state and read it yourself. Okay. All right. Goodbye. Have a good day.